May I please, Your Lordship? Your Lordship, I beg to mention item number 4, Your Lordship.
Item number?
4, Your Lordship.
Hmm.
Your Lordship, the matter may be passed for further days because Mr. M. Ahmed is supposed to appear in this case, Your Lordship, and due to his personal difficulties, he is not unable to appear, Your Lordship. Any date in the next week, Your Lordship. Perhaps his Wakalatnama is not there, Your Lordship. Today he will file, Your Lordship, Wakalatnama.
His name is there, not there.
Your Lordship, today you will file the Wakalatnama, Your Lordship. By mistake, your signature was not there, Your Lordship. Otherwise, in the particulars of the advocate, his name is
Secretary
there.
of the council for the petitioner. Matter is adjourned for 2 weeks.
I love Your Lordship.
Let the matter be taken.
I love Your Lordship.
Lordship. Lordship, I beg to mention item number 14, my lord. In this matter, Mr. A.K. Sharma will appear this matter, my lord. Due to demise his father, my lord. He could
Which
not.
A.K. Sharma, senior or junior?
Porup Kumar Sharma, my lord.
When did his father expire?
9th, my lord. Porup Kumar Sharma. Dhirendra Sharma. Earlier the session was Kasari Basti, my lord. Porup Kumar. His father, Dhirendra Sharma. 9th, my lord. Item 14, my lord.
And the part that Mr. A.K. Sharma, counsel leading in this case, is under bereavement. Registration is this matter after 2 weeks on it to weeks. Yes.
Okay.
Yes.
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 Your Lordship, I beg to mention a matter for listing in the orders column, Lordship. It is a writ petition challenging the order of Honorable Cat, Lordship, for orders, Lordship, next week, if possible, Lordship.
Why to be listed for orders? The reason?
Lordship, service has been completed, Lordship. It has been coming in the orders column, Lordship. So it is
When it
required
was
to
last
keep in
listed, it was
the-
left
it
out
was
or something?
listed, leftover, Lordship. It was leftover. On 29th, Lordship, it was listed. Lordship, it was last listed on 29th, Lordship. It was leftover.
Matter pertains to DB2.
Lordship.
Okay, we'll have it on 20th Tuesday.
Lordship. Much obliged.
Yes.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 13. Lordship, the matter may come up on some other date.
Burwa. It's not a Yes.
May I please, your Lordship? Lordship, I beg to mention item number 10. Lordship,
Hmm.
matter may be taken up after 2 weeks
Why?
because the youngest council, Mr. Yaman Hussain, has some personal difficulties.
There are many councils. Only Mr. Hussain is not. His name is not there in the. MI Hussain. Yes.
Yaman Hussain.
Leave note if they are advocates. And there are many councils. Mr. Motin was sitting here. We saw when we entered. Not at this stage. Not at this stage. This is 2018 matter. Yes.
May I please, your lordship? Lordship, in item number 1, we have filed one IA, lordship. But the IA may be called for,
What?
IA for correction of the cost title, lordship. Item number 1.
Where did you file?
On 12th, lordship.
Well, is it numbered?
No, filing number is
Not numbered. Then not today. We'll have it some other day.
lordship.
Listen Monday.
Lordship.
Give them a mention memo
Much obliged, lordship.
along with the I
Much obliged.
filed by the petitioner on 12/0. Yes.
Lordship, I want to mention item number 9 to be adjourned for today and fixed after 2 weeks.
Why?
The engaged council is ill. Engaged council is ill.
The 2018 matter. Let us see. Not at this stage. Number 2. That you. Events with number. Why is it before this court? TB2?
Lordship, it was. Lordship, I have no idea regarding that.
The TB1 matter, regular appeal.
Okay.
No, Maybe that's it. No. Technically. On the prayer of the council for the petition. Appellate. Sorry, appellate. Appellate this matter of 2 weeks on it.
Obliged.
To market.
Item number 2.
Okay, records are here. We'll take it after some time. We'll take it after some.
Yes.
Immediately the lordship. So as per earlier direction, lordship, I appeared before the SP lordship. Accordingly, lordship, my bail bond was granted. The LCR paras may not be not received lordship today.
Yes, sir, record was supposed to be produced by you.
We'll have to check it in the chamber, Lordship. It may be there.
Find out and let us know. It is BFT case number 247/2017, 15,
Yes, Lordship.
Foreigners Tribunal number 2, Kamrup, Boko.
Yes, Lord.
We'll take it after some time. Let's see whether records is available.
Lordship had sought for instructions whether the petitioner had ever appeared before the police. After the order was passed, never appeared, no bail bond submitted, Lordship.
I have received instruction, my lord, but due to ill health, my lord, 70 years,
Mr. Padgiri,
78 years old, my lord.
maybe
Ill health, my lord. He could not appear, my
will
lord.
reject the bail, to do whatever you like. This order was of 29 or 29.
2019 order, Lordship.
The initial order is of which year?
No,
Order, my lord,
The bail order is of
29.
September 2023, I think.
not Mr. K. Padgiri and counsel appearing for the petitioner. Yes, you are good.
my lord.
Yes. You are.
By this petition, I have challenged the impugned order, my lord. Kindly see page 72, my lord. Passed by the Foreigners Tribunal 8, Borpeta, in FT case number 151, 2018, my lord. Main, kindly see the name of the petitioner enlisted in the voter list in the year 1966, my lord. Page number 24 and particular, my lord, page 25. And thereafter, the name of the petitioner also included in the year 1970, my lord. Page number
Mr.
27,
Padgiri, please take a seat for a while.
my lord.
asking what is the paragraph 5 of your written statement?
My lord,
Come to your written statement at page 50.
Page 50.
Paragraph 5.
That my father name Moin Akon, son of Gomir, mother name Jomela Khatun, Moin Akon, husband name Idris Ali, son of Riyaz.
What is it? Jamila Khatun, wife of? Paragraph 5.
My lord.
Wife of Mayan Akhand, husband's name Idris Ali.
Husband's name Idris Ali.
If she is the wife of Mayan Akhand, how her husband's name is Idris Ali?
My lord, my father name's Moin Akon. It is clear, my lord. The son of
okay.
Gomir, mother's name Jomela Khatun, wife of Moin Akon, and my husband name Idris Ali.
Who's your husband? Your wife of Idris Ali.
No,
Yes.
Idris Ali, my lord. Can you say page 25, my lord? Idris Ali.
It's 78. Itu
When did your husband pass away?
My lord. Up to 1985, my lord, the husband name is included in the voter list, my lord.
That is why you're asking. Is he there? Is the husband alive?
At present, he is not more, no more, my lord.
When did he pass away?
Not in the record, my lord.
Your information, you have to disclose everything in the written statement. Ninety-seven voters list, his name was there.
Yeah, my lord.
Mr. Patgiri,
my lord. The Planet Tribunal, my lord, has not discussed anything regarding Exhibit C and D, voter list of 1966 and 70,
we'll come to that.
my lord.
Your name is Ajiran Nessa
Adiran Nessa, my lord.
regarding the voter list of 1966 and 1970.
My lord.
With village
Sargaon,
Sargaon of
T.S.
Bagbor
Bagbor,
constituency. Fine. In your written statement, you said that you have shifted
to Gamariguri, my lord. In the year
Mariguri due to
1980,
erosion.
due to erosion of the river Brahmaputra.
And your name figured in the voter list of 1985
My lord.
from village Gomariguri under Sokpur.
Sorbok LS, my lord.
After 1970 to 1980, where is your name in the voter list? Will you able to show us the continuity?
85, Lordship.
85.
Up to 85,
Yes.
let us see. You have shifted in 80.
80, my lord.
So after 70 to 80, where is your name in the voter list? There are parliamentary elections, there were assembly elections. What happened? You are projecting yourself that you are the Aziran Nessa
my lord.
of village Sargaon, wife of Idris Ali, whose name figured in the voter list of 1966 and 1970 under Bakbor Constitution. And at the same time, your name figured in the voter list of 1985 from village Gomariguri,
My lord.
relating to Torbhog LSC. What happened in between? Now please come to, you can read the vernacular.
My lord.
Very good. Come to page number 66. Look at your own evidence.
My lord. More naam Adiron Nessa. More Samir naam Idris.
Idris what? Idris Mondal.
My lord,
We do not- don't
there
read
is
to
a, my
us
lord, subsequently it was my lord, Mondal, my lord.
Say your
It-
voter list with Idris, your husband, you have said Idris Ali, and 66, 70. Even in 1985. We do not know. Then continue.
মোৰ জন্ম চৰগাঁৱত হৈছে মাৰ নাম জমিলা মোৰ বিয়াৰ এমাহ পিছত মোৰ দেউতাৰ মৃত্যু হয় মোৰ গ্ৰেণ্ডফাদাৰৰ নাম জমিৰ আকন কোন চনত জন্ম হয় মই নাজানো চৰগাঁৱত মোৰ এঠাইত মাটি আছে আৰু মোৰ ফাদাৰ ইন লয়ে সেই মাটি কিনিছিল
And you are trying to project that your father had land,
My lord.
land which you have inherited
My lord.
along with your brothers. But in your deposition, you have clearly said the husband, your name is Idris Mondal, not Idris Ali. And the land that you have at Shergaon belongs to your father-in-law. Now, please come to the deposition of your projected brother,
My lord.
keeping in mind that your father expired 1 month after your marriage. Your marriage took place in the year 1963. So please tell us the evidence of the TW2.
Page 68
Hmm.
মোৰ নাম জিয়াৰ আলী দ্বিতীয় পক্ষ মোৰ ইল্ডাৰ চিষ্টাৰ হয় মোৰ আৰু মোৰ ভনী চৰগাঁৱত জন্ম হয় মই কেতিয়া ভোট দিছো মোৰ মনত নাই
Now, please come at the page number 60, the top is 47.
Page 47
This was recorded in the year 15th of February 2019. Then if we minus 47 from 2019, this particular DW2 birth year was 1972,
my lord
whereas the petitioner clearly deposed that her father expired 1 month after their marriage that took place in the year 1963.
Hello.
Right? Now, please read the evidence of the Gaubra.
Page 70
Yes.
দ্বিতীয় পক্ষ আজিৰণ ৰেচাক চিনি পাওঁ দ্বিতীয় পক্ষ চৰগাঁৱৰ বাসিন্দা আছিল দ্বিতীয় পক্ষ চৰগাঁৱৰ বাসিন্দা ইদ্ৰিছ আলীৰ লগত বিয়া হয় দ্বিতীয় পক্ষৰ দেউতাকৰ নাম ময়ন আকন বৰ্তমান দ্বিতীয় পক্ষ নদীয়ে গাঁওখন
ভাঙি
নিয়াৰ বাবে গামাৰিগুৰি গাঁৱলৈ চিফ্ট কৰে দ্বিতীয় পক্ষ সৰুৰে পৰা চিনি পাওঁ Exhibit H মই দিয়া
certificate.
certificate H1 মোৰ সহি
More Sohi. Then
my
the
lord
tribunal inquired from her.
my lord
Just see.
মই গাঁওবুঢ়া 1980 চনত হৈছো দ্বিতীয় পক্ষ কেতিয়া বিয়া হয় ইদ্ৰিছ আলীৰ লগত মই নাজানো দ্বিতীয় পক্ষই চৰগাঁওখন নদীয়ে ভাঙি নিয়াৰ বাবে গামাৰিগুৰিলৈ চিফ্ট কৰে বুলি অনুমানত কৈছো দ্বিতীয় পক্ষক মই চিনি পোৱা বাবে দ্বিতীয় পক্ষৰ দেউতাক মই নাকন বুলি কৈছো দ্বিতীয় পক্ষক মই চিনি পাওঁ আৰু সেইবাবে মই চাৰ্টিফিকেট দ্বিতীয় পক্ষক দিছো মই চাৰ্টিফিকেটত 45 ইয়াৰ্ছ ধৰি গামাৰিগুৰি গাঁৱত বসবাস কৰা বুলি অনুমানত লিখিছো দ্বিতীয় পক্ষ
দ্বিতীয়
জন্ম
পক্ষৰ জন্ম
চন মই নেজানো মই কোনো ৰেকৰ্ড ভেৰিফিকেশ্যন কৰি চাৰ্টিফিকেটখন দ্বিতীয় পক্ষক দিয়া নাই
so he doesn't know the father of the petitioner only as he know her,
my lord
right?
my lord
Knew her, that's why he has given the certificate, not on the basis of any verification of records or anything.
my lord
He is also not aware when did the petitioner took her. So the certificate issued by this village headman,
গাঁও
because other things have not been proved. So we are not on that. The certificate is at page
my lord page
36.
36
47, vote taking with the 2019. Vote list. So, Mr. Padgiri, you are aware of the fact that whatever evidence to be adduced by the petitioner to prove his or her nationality, the concerned opposite party is required to give his or her evidence.
my lord
That can be accepted as a piece of evidence. Should be reasonable, potent, reliable.
my lord
After reading the evidence of petitioner, the Gaambura, and protected brother, as a court officer, Mr. Padgiri, kindly tell us whether tribunal committed any mistake. Whether by discussing or not discussing, we are not asking you.
my lord
Do you think that this evidence is potent, reliable, and acceptable?
my
Tell
lord
us as a court officer.
my lord my lord my lord that
First of all, instead of Idris Ali, it is Motrol. Secondly, land was of her father-in-law at village Saregaon. Then the part of her projected brother was of 1972, whereas her father expired 1 month after her marriage in the year 1963. Secondly, the village headman, Gaambura, certificate is clearly stated not been given from verification of any record. It has been given only as he knew her,
my lord
right? He doesn't know when she was born. He doesn't know who was his father, her father. Right? So,
my lord
Anumanik. What do you Anumanik? Assuming. When there is an assumption or presumption, can it be acceptable as evidence?
in the my lord land
Just tell us
document my lord I
whether
have
these
annexed my
kind
lord
of evidence is reliable, potent, and acceptable
my lord land
to
document
prove a nationality. Yes, right. Now, land document, if you are saying, how will you connect it when your father has expired in the 1963
Hmm.
and your brother born in the 1972, whose name figured in the land document? It may not be the same father. It may be some other Moin Akhtar. Cannot be that particular person whom you are projecting your father.
and land property inherited my lord the
When the procedure
to the
herself says
petitioner
that belongs to her father-in-law. Only you know not Mr. Patkiri, but the petitioner is aware.
Lordship, there is a contradiction also in the WHD says they shifted from Sargaon to the Gamariguri because of erosion. So if erosion had taken place, then where was the land in Chargaon? Because this circle officer's report is of 2007 and they shifted long time back. If erosion had taken place, land would not have been there. If Lordship comes to page 52 or
Only that,
WS,
not only that.
and no, that
You
is,
see
title is
the,
also of a different person. The-
you read the evidence of the village headman.
That is
There at page
16.
71,
Yes,
the village
Lordship.
headman has clearly stated. দ্বিতীয় পক্ষই Sorgaon Khon, the village Sorgaon was eroded.
Yes,
The village Sorgaon.
yes, Lordship.
Then question of her brother, if you see the address of DW2 is Sargaon.
Yes, and if the village was eroded, Lordship, that land would also have not been there. My submission
Probably
was,
while studying law, you know the fish follows the river. The very first year you might have read it.
page 33 is contradictory to what is stated, Lordship, in her WS. And even the Gaubura states that the village was eroded.
No, yeah, take it. Yeah.
You were 7 brothers and sisters.
My lord.
You were the eldest or what?
Stated in the WS.
I think you were the second.
Second, my
The
lord.
first one had predeceased, I think, Jubair. Jubair Ali died death you have written. So come to the voter list, which you have annexed.
Sixty-six, Lordship,
66
and 70.
at yes, page 20. '66, 1966 voter list at page 21.
my lord. It is the my lord, name of the my lord, father and mother of the petitioner. My lord.
And third is
Jubbar Ali. It is the my lord, uncle, my lord, most probably, my
not
lord.
uncle, his elder brother, his first
Elder brother.
He's 22 years old. Just turn over the page,
Moinuddin.
come to page 23.
Moina Khan, Jamila Khatun, Jubbar Ali. As per WS, my lord, he was died.
Mile.
See, you have given a voter list. There is no voter list of you and your parents.
My lord.
Because you say that 66 you voted for the first time and you were 21 and your voter list is there with your husband.
My lord. With husband.
1966,
My
okay?
lord.
Similar condition was there in 1970. Husband and petitioner.
My lord.
In 85 voters, thereafter from 70 to 85, no voters. It's a long gap, 15 years.
My lord.
No explanation. 85, husband is not there. Why?
In the year 1980, my lord, they were shifted to my lord, village Gamariguri, my lord.
That is okay.
And-
In 1985 voters list,
My lord.
you come to 1985 voters list at page 30, 29 and 30.
My lord.
See, you have projected that this is you, Ajeran.
Ajiron Nessa.
Husband's name Idris
Idris
Ali.
Ali.
Where is Idris Ali as a voter?
My lord, Perhaps, my lord, it is there in the voter list, my lord. As kindly see, my lord, page, my lord, 1997 voter list, my lord. Their name is there, my lord, but it is the certificate copy, my lord. Only, my lord, given, my lord, 695, 696, my lord. It may be, my lord, 698, my lord. Their husband name is also included, my lord, but not provided, my lord.
Maybe will not do it, it's your duty.
In 1997 voter list, husband name is there, my lord. Page 32.
Certified copy?
No.
No, my lord, it is not certificate
Why?
copy. my lord.
This is a
Why?
list. Enumerated list.
You could take out certified copy of all the documents, why not this? Let us check this
This is the enumerated.
uncertified copy to its history.
It took about people.
Now, in 1997, my lord, the petitioners, my lord, declared as D voter, my lord.
Yeah.
Okay, just compare 30 in page 30. Husband's name was not there. Okay, you say that maybe it's certified copy, it is not been reflected. Cannot be because it's under the same serial, same house number. Nonetheless, it has got two other names,
My lord.
Ahmad Ali and Jahara Khatun. Okay,
Ahmad Ali and Jahara.
you have projected in your written statement that Ahmad Ali is your brother-in-law and Jahara Khatun is your sister-in-law. You have stated in paragraph, page 50 to paragraph 14. Page 52, paragraph 14. Correct?
My lord.
Brother-in-law and sister-in-law.
Sister-in-law.
Okay. You come to the 97 voter list uncertified copy. Let us assume for the time being, let us examine this. Here Idris again comes.
Aziran Nessa.
And Azir, where are these two names? Ahmad and Jahara?
In that list, my lord, their name has not been recorded.
Why?
Mr. Patiri,
My lord.
page 51. Para 8. You have said that out of the wedlock,
7 child, namely.
7.
Ishatan.
Paragraph 8. Isana Khatun, her name is not there in the voter list. Kodbhanu, her name is not there in the voter list. Then you said your son is Surhab Ali. His
Hello.
name is not there in the voter list. Then you said Intaz Mondal, but name of one Intaz Ali is there.
my lord.
Then Hajara Khatun, her name is not there. Then we said Montaz Mondal. There is no son, there is Montaz Ali.
My lord.
Then Azizul Haq, his name is not there. Now,
I-
where this Sohrab Ali left for? Your son? Why his name is not there in the voter list? Your projected voter list. Let us assume it's a valid voter list.
My lord.
Anything else? So you know the outcome.
Mind only the contention that my lord, the 1966
See,
earlier
see,
1970.
we are not disputing on that. A lady by name Aziran Nessa, husband of Idris Ali,
My lord.
figured.
Right.
66, 70, fine. Thereafter, the name figured only in the year 1985.
Well,
You say it. But the husband
Husband
name is
name
not
is
there.
also
And you said you have shifted to village Gomarigaon because of the erosion in the river,
my
in
lord.
the Sanpara. Now, thing is this, if you could have shown that this Aziran Nessa, wife of Idris Ali, because up to 1980, she was in the same village.
My lord.
After 1970, you came only after 15 years. Why? Why after 15 years? That itself indicates something else and it appears to be fishy. That evidence you should have in place before the tribunal by adducing the evidence of the voter list.
No, no.
We have no doubt that one, Aziran Nessa, wife of Idris Ali of village Sargaon's name figured in the voter list of 66-7. Thereafter, what happened? And you have seen the discrepancy. Voter list, one. Secondly, you have clearly said husband, your name is Idris Mandal. Thirdly, land is of your father-in-law. And if that man has expired in the year 1963 itself, how do your other brothers sisters born? So that particular person, Mr. Rakan, whom we have projected father, Moina Khan, is somebody
Moina.
else, not your father. You're projecting him as your father.
Hmm.
Cannot be your father. Even the village headman, he doesn't know your father. Not on the basis of any record, nothing, he said clearly. Only because he has the affinity to you, that's why he has given that certificate. Then what else?
my lord,
If certificate, the village headman certificate goes, existence of your projected brother goes, what remains? That land document is also gone. Because that brother could not have been a son of that Mayana Khan who expired in the year 1963.
and subsequently, my lord, the name of the land, my lord, mutated in that.
How can it be when this particular matter, Jamir Ali, who adduced as an evidence as DW2 as your projected brother,
My lord,
was not there in the year 1963, could have acquired the land or inherited the land of your projected father? And the procedure has rightly said, land belongs to her father-in-law. Because she is not at all aware. It is the lawyer
my lord,
who is giving the documents. She doesn't know where from she will say.
record available in the.
Whatever is there, mix and match. Column A, column B.
My lord,
Had this lady, an Indian citizen, without any doubt, she could have placed the voter list of 1970, after 1970 to up to 1980. There are 2 state elections, 2 parliamentary elections. What happened? Her name was not there. Why?
but,
The reasons are simple. Once while these issues were going on, one ACS officer during that point of time, Mr. Payang, if you can get hold of that particular news report, it was shown in TV, national TV, Doordarshan, everywhere. The lady contested from Botadra constituency, she was an ACS officer. After that, she has joined a party, contested the election. Openly, she was saying in her election campaign, you have to vote me because I have inducted your names in the voter list. Nothing was required, it was inducted. It was clear. But election commission did not take any action, nor the deputy commissioner, all the electoral officer to verify those names when there is an open statement. But anyway, it's a different part. We cannot look into all these aspects unless the reference are there, tribunal decides it. So you can understand that names were inducted like that.
but description regarding title, my lord, in that point of time, my lord, there is a, my lord, the situation is not, my lord, therefore, my lord, the electoral, my lord.
Mr. Patgeri, that kind of submission we cannot, that will not help you anyway. We have to, in that periphery, you have to be there, right? What are evidences there for the rightly placed, proved, cogent, reliable, and acceptable. Whether that is the reason we ask you, whether these evidence after reading it, after verifying it, do you think it's a reasonable, cogent, and we have not even opened the record. We don't know what things will come out from the record. From your annexes and only we are here. So what order should we pass? Now tell us, Mr. Patri. Makin document. Itu एकतर मोठे from Take your seat, Mr.
My lord.
Sorry. Down now equally. You know, to one L now, I, capital. Use the in Martina too. Ronnie, in that number is 8XQE1. BYPHO. No, capital. Yes. Ms. Verma.
Yes, Lordship.
Whether the proceeding could show that her father is Moyen Akan in absence of the, if we discard the certificate issued by the Gaumra.
No. Lordship, can I start from the continuous stay part? Because 66, 70, going by the material on records, Lordship, this lady has not been able to prove that the 66, 70 voters list and the 85 and 97, she is the same person, Lordship. Because all her documents are contradictory to what she has pleaded in the WS. In her deposition, she has stated her husband's name as Idris Mondal. So documents say otherwise, and her statement before the tribunal is different, Lordship. So maybe Idris Mondal does exist, but because there's no document of Idris Mondal to be brought before this court, Idris Ali's documents have been picked up and projected as her husband. This is my first argument, Lordship.
Where is the contradiction?
Evidence, Lordship, her evidence, she has stated in her prayer, Lordship. Hmm? 65, no? Page 65, Lordship. Or note to the tribunal, Lordship will take note of this. My name is Arjan Mehta. My husband's name is Idris Mondal.
Hmm.
I was born at Chargaon. My mother's name is Jamila. My father died immediately after 1 month of my marriage. My grandfather's name is Jamil Akan. I don't know when I was born. I have plot of land at Chargaon. My father-in-law bought the said plot of land. And in her document, she has said that she has inherited the land from her father. The land documents annexed to this petition at page 33, Lordship.
Difficulty is her grandfather was not Jamir Akan. Land document is in the name of Gamir Akan.
Yes, Lordship. That is. Yes, Lordship.
Voter list is also Gamir. But she said that her father, grandfather name is Zamir.
Jamil. Hmm? 97 million. Lordship, then the continuous stay part 6A2 of the Citizenship Act, Lordship, 1955. May I read it?
Page.
Lordship, I'm reading from the Citizenship Act 1955. It's page 174 in my book, Lordship. It says, subject to the provisions of subsection 6 and 7, all persons of Indian origin who came before the 1st day of January 1966 to Assam from the specified territory, including such of those whose names were included in the electoral rolls used for the purposes of the general election to the House of the People held in 67, and who have been ordinarily resident in Assam since the dates of their entry into Assam, shall be deemed to be citizens of India as from 1st day of January 1966. Subject to the provisions of subsection 6 and 7, every person of Indian origin, A, Lordship, who came to Assam on or after 1st day of January 1966 and before the 25th day of March 1971 from the specified territory, and has since the date of his entry into Assam being ordinarily resident in Assam, that ordinary residence staying in Assam and continuous stay has not been proved but through her documents.
You are reading 16, section 6A2.
6A2, Lordship.
Hmm.
6A2B.
Hmm.
And my stress is on B, Lordship, that she has not been able to prove her continuous stay.
6A2B.
Two complete and then B, Lordship.
2 and 3.
2 and 3. 2, 3, 3B.
Hmm.
To that effect, we have a judgment. I don't have a copy. Can Lordship check it up? 2019 5 GLR 768. If I'm correct, the
I think
name.
we have given you the equivalent citation earlier. Yes.
After
You
it,
have. Okay, we'll have it for you. Name.
Name is
Monoduti M. Nandi, Lordship.
That's right, that's right. He was just giving you the citation.
Yeah, I have just got it, Lordship. Paragraph 678. May I read it, Lordship?
Just a minute, just a minute.
By the way.
Yes, 90. Do you have the what is the name?
Monoduti, MONODUTI.
DUTA.
DUTI.
No, duty.
Monoduti. Nandi, NANDI. It was, WPC number is also there, Lordship.
Yes.
WPC number is 8779 of 2018, decided on 21/1/2019.
855.
8779 of 2018, decided on 21/1/2019.
Monoduti Das.
No, it's Nandi. Monoduti Nandi.
MONODUTI.
Yes, Lordship.
Not to create it. Which para?
Paragraph 6, 7, and 8, Lordship.
6 relates to the provisions of section 6A.
6A3, which I just read out, Lordship.
Then 7.
7 relates to the registering with the Foreigners Registration Authority, and 8 relates to the order, Lordship. For us, 6 is important. Paragraph 6, Lordship, for this matter.
Reported 2019.
No, put it. Five here, 7, 6.
6A3, Lordship, paragraph 6. Has Lordship found it?
Yes.
So continuous stay lordship, for that I'm referring to this, and another document which I'm referring to is 2017 lordship.
Hmm.
2017 4 GLT,
2017?
4 GLT,
Hmm.
346 Rashmi Nara Begum lordship, where it says it's on the proposition of material facts pleaded would have to be proved by adducing cogent, reliable and admissible evidence. Paragraph 25 lordship.
Just a minute. Hmm. Paragraph?
25 lordship. Written statement is the basic statement of defense of a proceeding before the Foreigners Tribunal. Keeping in mind the mandate of Section 9 of the Foreigners Act 1946, it is incumbent upon the proceedee to disclose at the first instance itself in his written statement all relevant facts, especially within his knowledge having a material bearing on his claim to citizenship of India. Material facts pleaded in the written statement are thereafter required to be proved by adducing cogent and reliable evidence. It is also tried that a party cannot traverse beyond the pleadings made in the written statement. And another citation which we would like to rely on is 2017 2 GLT 1076.
1076?
Yes, Momin Ali versus Union of India. This is on variance between pleading and proof not permissible.
আহিছিলা পাতি কাটি গৈ which para?
Paragraph 13, Lordship.
20
13.
13?
Yes, Lordship.
Hmm.
It is a settled proposition of law that where a party fails to set up a case in his pleadings, he would be debarred from adducing evidence in his support at each stage of trial. That is not important. As a matter of principle, variance between pleading and proof is not permissible. Then, Lordship, can we come to paragraph 18? End result of the above discussion is that the petitioner could not successfully discharge his statutory burden under Section 9 of the Foreigners Act to establish his linkage to his parentage on the Indian soil prior to 71. In such circumstances, we do not found any good ground to interfere with the orders of the tribunal. And shifting has not been. We went to the land saying that it's a party, that it is the party interest. No. 15 has not been proved, and for the sake of proving that she's a citizen lordship, again she went back to the land documents, the Jamabandi, which is annexed to that part of the village where they had earlier shifted from. That is Shargaon. They shifted from Shargaon in 70 as per his submission. And in 2017, 2007, they had this Jamabandi from the village. Maybe this is just for the purpose or documentary proof to show that her existence in India lordship. And the land referred to is that of her father-in-law and not of her father.
CC.
Yeah. It's her statement, lordship. Lordship, there's one more judgment I would like to rely on, Lordship, that is Orhan Ali to respect to negative one है ना report one है. ना तो से enumerators list. कोई कोई repeat हुई.
Yes.
Lordship, I would like to rely on one more judgment, that is Borhan Ali Lordship. That is on the proposition of that the voters list has to be relied on in it, not in part, in complete Lordship. That judgment is at WPC 7669 of 2016, Borhan Ali, paragraph 27.1.
WPC
7669
15,
16.
2016,
Yes, Borhan Ali,
BORHAN.
BORHAN, decided on 8/6/2018.
86,
Yes, Lord.
2018.
18. Paragraph 27.1. May I read it, Lordship? Extending this principle, if a proceedee relies on a voters list, he has to rely on the same in its entirety and not in part. He cannot say that he will rely upon part of the voters list which is favorable for the proceedee to the proceedee, but will not rely upon that part of the voters list which goes against him. For example, vital discrepancies in name, residence, and age. A document has to be appreciated as a whole, not in bits and pieces. In 1997 voters list, Lordship, that is just an extract of a voters list. It is not the certified copy. For that, I would like to rely on one more judgment. WPC
Earlier you said 27.1.
27.1, Lordship. 27.1. It starts with extending this principle. And on the extract of the voters list, Lordship, this is WPC 6280 of 2016. Tuta Mia, Lordship, TUTAMIA, Elias Mohammed Tota Mia, MD. TOTAMIA. This was decided on 14/5/2018. Paragraph 17.
14/5/18.
Yes, Lordship. Paragraph 17. In so far Exhibit 2 is concerned, it is an extract of the voters list of 2014, whereby voter was Abdus Samad, son of Tota Mia. This document is not admissible in evidence because it is not a certified copy. Therefore, it is neither primary evidence nor secondary evidence. Even then, if we accept the document at its face value, it only shows Abdus Samad to be son of so-and-so, but there is nothing on record to trace the existence of Tota Mia on Indian soil prior to 27/3/1971, which is the cutoff date for identification of foreigners in the state of Assam as per Section 60 of the Citizenship Act. And the universal judgment of writ of certiorari, I'll rely on that also.
Anything?
That's all.
Want to reply? No.
Regarding title, my lord, so discrepancy in title, my lord, I relied
Surname,
upon
surname,
my lord,
not title. Surname,
surname, my lord,
not title.
my lord. I have relied the Supreme Court 2019 5 SCC
Sariful Islam.
Sirajul Islam.
Sirajul Islam.
Sirajul,
Read that paragraph 3.
my lord.
Read that paragraph.
There is no doubt that the great grandfather's name, Amatullah, appears at Amatullah throughout the document. Equally, there is no doubt about the father's name, which appears as Hakim Ali throughout. The only discrepancy found in that in some of the documents, Kafatullah later becomes Kamatullah. However, what is important to note is that his father's name Amtullah continues as Amtullah and other family members associated continued as such. Also produced are NRC registration details in the of the year 1971 of the grandfather who is noted to be Kafatullah in this document. Other voter lists are then produced where the letter F becomes the letter M with other family members remaining the same. In fact, the appellant has himself produced a document of 1981 from the income tax department giving his permanent account number. Apart from this document, certain other letter documents have also been produced, including photo identity cards issued by the Election Commission of India and identity card issued to his brothers, including voter list in which the appellant's name appears. Giving gone through this document, we are of the view that it is not possible to state that the Kamatullah is not the same, despite being named Kafatullah is stem of the document. This being so, the grandfather identity, father's identity, has been established successfully by the appellant. Further, the mere fact that the father may later have gone to another village is no reason to doubt this document. We therefore suggest the judgment of the High Court as well as the Foreigners Tribunal.
The reason there is, the voter list, that continuity of the voter list, all these years are there.
My lord.
Shifted to another village, their name figured.
My lord.
There was no gap in that village. There was no gap in those voter lists. Continuity was there. And secondly, name of the grandfather, father, everything remained intact. And the name of the other brothers, sisters in that voter list.
My lord.
Even if you read that judgment, the house number is also the same. Only one particular letter was not
Kafatullah
there.
and my lord.
That is why in that case, in that context, the effect put. But it is not in your case. There is no continuity in the voter list. You said your grandfather name is Damir, where a land document is Damir. Right? Huh?
Give the citation again.
2019 5 SCC 534.
Many of you are placing this judgment without reading this contract.
2019, 5 SCC.
5 SCC 534.
Para 8.
There are three.
There it has, if you read para 1 and 2 also, you will see.
No.
They have given all the description. In that circumstances, the Honorable Appellate could have considered it as not because in violation of the provisions in the Election Commission of India or the other provisions. Anything else?
No.
Part Mr. K. Patkiri, counsel appearing for the petition. And MSA Verma, attending counsel from Department of South Africa. 257 257 H. Kuli on behalf of AIR. Order.
Oblige.
May I please your lordship, my senior is election code number 23 Kindly your lordship takes at 2 p.m.
You make it read the WS. Let us see what is there.
Your lordship, the order is in page number 40, your lordship. 22/11/2020. Order dated. If you, your lordship, page 41, paragraph number 6. It says that the full bench of the Honorable Guwahati High Court in State of Assam and others versus Muslim Mondal held that in an ex parte proceeding before the tribunal constituted under the provision of 1964 order, the said portion would not be changed as the burden of proving that the proceeding is not a foreigner continues to be upon the proceeding, which cannot shift. We accept that, your lordship, but if you see the voter list, your lordship,
What is your explanation for not contesting?
I beg apology, may you please
What is your explanation for not contesting? Why didn't you contest the proceeding? Your advocate took time and time was granted on numerous occasions.
Your lordship, I'm not well versed with the facts of the case. I need to take instructions from my senior.
No, we are not asking you any difficult question. You have just read paragraph 6.
Yes, sir.
Paragraph 6 has been laid down in the context of an ex parte proceeding.
Yes.
If you read paragraph, the lines in the same page, page 41, the paragraph, the topmost paragraph, continuation. OP was absent only if OP's engaged advocate takes time. Duty of the tribunal is to provide, to prove the burden that he is not a foreigner but a citizen of India. Again, he was given opportunity to prove his nationality on so and so 4 days. But OP remained absent without step. In all the above mentioned dates, the tribunal had no authority to pass next verdict.
Yes, your lordship. Basically, what happened, your lordship, notices were served by the tribunal to the
Proceeding. Yes, petition.
proceeding,
Yes.
but your lordship, it was not received by him on hand, and he was not aware of that.
Your advocate was there. How can you go back now that the notice was not received? Your advocate was engaged. If you have not received the notice, how will your advocate appear on your behalf?
But your lordship, there is also a fact unknown to me that why the advocate is to take time in the learned tribunal. Your Lordship.
Have you taken any action against the advocate? Have you lost any complaint?
As per my knowledge is concerned, no, your lordship.
Then once you give the wakalat number, you give the entire power to the advocate. Now, if the advocate neglect, then you have recourse in law what to do. You have not done anything.
Indeed, your lordship.
You did not even file your written statement.
Sorry, my lord, I was in court. My lord, impugn order page 39, my lord. My lord, my case, the other day I have submitted that my case is not so good in a sense because I appeared thereafter I disappeared. But the thing is this, I have so many papers to prove my
You
citizenship.
did not disappear. You disappear, you'll be missing. You appeared and you did not appear thereafter. Not disappearing.
So, but the reasons was that, my lord, that is medical ground. And my lord, so many orders are there of the Honorable High Court as well as the
order of 2013, my lord. There is the provision of issuing warrant of arrest. That is not done. However, I have not done that. After all, this is a question of citizenship, and there are so many judgments of our High Court as well as Honorable Appellate Court also, that one judgment I have brought to be seen, and there are other judgments also, my lord. Kindly see.
What is your medical issue?
Medical issue, my lord, I have arranged.
What are the documents?
Yes. Kindly see page 29.
Yes. So
Yes,
any document where you've been diagnosed of anything?
Yes. That is there, this is Baharul Islam. So it is of SARS, Spars Hospital. And this is next Rongia Model Hospital.
And what is your problem? What is the disease? What is the ailment? Any
Actually,
document?
these are doctor's language, but
No, these are
I-
prescriptions.
prescriptions are there. Prescriptions. That is
Cough syrup.
diarrhea. Diarrhea was there, page
Where?
36. Page 36.
36.
Yes. Then, my lord,
Where
it is
diarrhea?
page 36, kindly see left side. That was one disease is there. Another is page 38. This is also the prescription. Huh? This is pain in page 38. Page 38, this is another disease, not only one disease. So,
What is your problem? What disease? Diarrhea and cough syrup.
a relevant series, my lord. I am reading the body portion. Page 6, para 5, can list.
6, para 5.
Yes.
Yes.
That the petitioner makes sure that the reference made against the petitioner expressing doubt about his nationality was registered in the Foreign Tribunal, Pakistan on so and after registration, the case notice was issued to the petitioner on 3/6/23, which was received on 23/6/23, and on the said date, the petitioner appeared along with his advocate with a pair to allow some time to file his WS and evidence in SIV. Unfortunately, due to serious illness and prolonged sickness.
Yes. What was your sickness? We
Those
have
are-
read this. After reading this only, we are putting the question.
Yes, those are not actually satisfactory, my lord. But
Some documents,
no, kindly see this
some documents,
documents. What is document that is? I have already annexed.
some pathological test or some clinical test or anything, any diagnosis.
Actually, he is now here and there out of position. Yeah.
Cold one day and stomach trouble one day.
My submission is not so much on merit, man. My submission is that a judgment is also there in our High Court, my lord. Supreme Court judgment, I have once given judgment. The judgment said, for a moment, Lordship may kindly see, which I have copy I have furnished. Page 3, kindly see.
Please read the citation.
Yes, that is WBC 6544 2019, Asaruddin versus Union of India. Order dated 9/9/21. Now, Lordship would kindly see para 4. The present petition has been filed by the petitioner for setting aside the ex parte order that is so and so, passed by the landed member Foreign Tribunal 2nd Morigao, Assam in application number so and so, by which the petitioner was declared as a foreigner under section so and so, because of failure to submit written statement by adducing evidence. Then Lordship kindly see page 4, my lord. There are 7 and 8.
Yes.
There are 7, 8, and 9. However, we are of the view that citizenship being an important right of a person ordinarily should be decided on the basis of merit by considering the material evidences that may be adduced by a person concerned and not by way of default, as happened in the present case, as default. So in the present case, the petitioner has drawn our attention to the voter list of 1965, 1970 and 71, wherein the names of his grandparents, parents and petitioner himself have been shown to be included in respect of village Shohoria Pam, Mauja, Moirabari, district Nagaon. So that is his documents. Exactly, it is in similarity with my case. Then Lordship kindly see para 9. Considering the circumstances as narrated by the petitioner, we are also of the view that there were sufficient reason for petitioner for not being able to appear before the Foreigners Tribunal to enable the tribunal to consider his claim on merit, and accordingly we are inclined to afford another opportunity to the petitioner to appear before the Foreigners Tribunal to prove that he is an Indian, not a foreigner. So accordingly, my lord, case was sent back, but there was some condition. If he does not appear, then order shall be automatically cancelled. So my submission is this, my lord. This is one of the reasons for which your lordship may kindly consider this. So for other reasons, my lord, I am coming to one citation that lordship may kindly see, page 17. Sorry, yes, it is a reported case, my lord. It is a reported case of, that is 2022. 2022, 1 GLT 756. Here, para 7 and 9, my lord.
Name?
Name Rajendra Das. My lord, actually, I have written a book. I have given my lord justice. I am giving your lordship another copy.
Paragraph?
Paragraph 7 and 9. I am presenting a your lordship. Your lordship, it was decided by our High Court. Can you see page 21 of that book, my lord? It is duly referred, case number and para also. Here declaration as foreigner. Can you see 9? 9. Go through the Foreigners Tribunal's Amendment Order 4E of 2013 for issuance of warrant. If proceeding does not appear or disappears, there is no provision that due to non-appearance, a person can be declared as foreigner. This order is printed in the last part of the book. So this is one thing, my lord. Then here, paras.
Why have you cited Rajendra Das?
Rajendra Das, because she did not, first she appeared, thereafter did not appear. So like my case, man. So court said that.
Rajendra Das is in the same lines of Asaruddin. Same lines of Asaruddin.
Yes, same line with Asaruddin. Repeated judgments are there, and
Asaruddin, you have cited that ex parte award was set aside and
yes,
was
yes.
remanded.
Asaruddin, another case. This is another
Rajendra
judgment.
is in the same line.
Same line. And now the Supreme Court has said on repeated occasions that court should follow the decision of the coordinate bench, and under any pretext, court should not deviate its stand from the earlier point, because then there shall not be any judicial discipline. One bench is passing this type of order, another bench is passing that type of order. So there will be conflict among the.
Which case?
My lord?
Which case?
Yes, my lord. Those things are there. Page minorities reported case 2004 5 SCC 568, para 6.
2000,
2004, 5 SCC, 568, para 6, my lord.
2004, 5,
So that is a judgment.
568.
568, para 6. This is state of Odisha versus Dhoniram Lohar.
Para?
And para, my lord, 6. And another judgment, lordship may kindly consider.
What is there, paragraph 6? Please read.
Paragraph 6 is saying that judicial discipline is an important maxim of law, and the declaration of law by Supreme Court cannot be forsaken under any pretext by the authority or court. It is elaborately say including High Court. What?
Read that part, read that part.
That is para 6 where it is written.
No, it's Supreme Court only.
2004 5 SCC 5
No,
6.
yeah, that's only reference to the Supreme Court judgment. Where is the High Court and bench? What is the observation?
The High Court stood 22 I have given another Asaruddin
No,
Jarasuria.
this proposition
Yes,
of judicial discipline.
yes.
This
Yes.
is only with regard to Supreme Court judgment.
With regard to Supreme Court judgment. The Supreme Court has also said that the judicial discipline should be followed.
What is the wording? You just read it again.
Judicial discipline is an important maxim of law.
Yes.
And declaration of law by Supreme Court cannot be forsaken under any pretext by any authority or court. And I remember the word including the High Court, highest court of the state. That is also
You are
there.
reading from your book.
My book, from my book, but it is.
We are getting that judgment, don't we? Just
So
2004, 5
5 SCC, 568 para 6 can be seen.
Just coming.
2004, 5, 8.
Any by apna
Page number.
apna kitab diso apna.
568.
568.
I have given a book to my learned friend also.
Actually, that book.
And my lord, another decision, 2003, 5 SCC, 448, para 10,
2003,
5 SCC, 448, para 10.
Name?
State of Bihar versus Kalika Kuber alias Kalika Singh. Latter coordinate bench is bound to follow the earlier decision or refer the matter to larger bench, that is para 10. And my lord, my last pair is regarding that 2013 amendment order, which lordship may kindly see in my book, page 138, I have reprinted it, 138. Operative portion may be seen page 144, my lord. Here, the amendment was that the procedure of and power of foreigners tribunal easily should not declare a person a foreigner. Only that can be done after exhausting all the alternative procedures. So here, my lord, no, it is in the order itself. Order E, 2013, this is a Foreigners Tribunals Amendment Order, 2013, sub-order 3A, 3A, E, 3A, E.
Warren.
Yes, warrant. So here, my lord, the learned tribunal could have taken this, then you would have been compelled. But instead of taking that very shortcut way, that tribunal declared him foreigner. However, I am not so much on merit, man. I am not so much on merit because I have also fought. So my only limited prayer is this: lordship may kindly remand the matter and some cost may be awarded. Though in earlier cases, there was no cost in many cases, but even if your lordship is under discretionary power, may award or may not award. So I may be given a chance. If I fail to appear or as per direction of this honorable court, then I will face the consequences. That is limited prayer. So for merit, I do not say so very good case.
Decide. আপনি দেখুন সব সাবমিশন দিলে ফাইনৰো দি দিলে আজি মই ক'বলৈ একো নাই
দোষ হয়েছে তো
আপুনি আমাৰ কাৰণে কিবা এৰিব লাগিব না
আপনি কই তো 1 লাখ দিব না মই কো 1000 দিই
মই জিৰোৰ ওপৰত নকওঁ
only that prayer matter. Some cost may be awarded, but I should be given a chance. I am in Indian, but due to my negligence, this thing has happened. Dalet tribunal is also otherwise correct.
No. बोले नहीं जाता हमारे business.
Yes. 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 Because I was told by the counsel who brought the case to me that he never accepts such type of petition. No, it was not filed, but in that view, he did not file. If your lordship directs to that action, I am ready. Yes, it is in law, but he does not allow. I am told that Ladet Tribunal does not allow all this. So, instead of going as per the procedure, that is 382, directly has come to the Honorable High Court. In other cases also, party has directly come because tribunals are following their own procedure. Although there is the Muslim Mundal's case, in para 103, there are detailed procedures laid down, but the tribunals are following their own procedures now in various tribunals. So that's why, my lord, sometimes I think your lordships in your discretionary powers may also conduct a training that why they do not follow the only one procedure. Different tribunal, different set of minds, members are there. Yeah. That liberty lordship may kindly grant us. After all, I should be given a chance to prove my citizenship.
Enough.
Yes. Not properly, sir. Then in that view, liberty may granted and case may be disposed of. I will go. No. These are poor men, my lord. How they can fight with. Any complaint, rupees 1,000 has been deposited. Every time he has to come. So these are almost next to impossible. For such type of men, of course, somebody comes, no doubt. But for such type of men, instead of fighting their own case, they fight with their lawyers. Next. Table. Clear with opposite again. Clear at the clear to the
NMS A Verma. For number 3, 6, 7. H. Kuli for AI Ali 2. P. Sharma. Oh, better. Here is the record.
I have given present.
In origin.
Not like this. Open to the library.
Here is the record. Case number 21 of Baksa of the Please report the court. No, preparing the implement ex parte order. Dated 22/11/2023. Passed by the Learned Furnace Tribunal Baksa. Placed by, placed by Mr. Deesan. Turning counsel. The record which earlier order. Order is up.
Lordship, we would also like to rely on some citations here. We would also like to rely on some citations in this matter.
You have?
Yes, Lordship,
Okay, give it as a 2 o'clock.
we'll give.
Only will keep the date,
Yes.
but this order will record.
My lord, at 2 p.m. I have another matter.
Doesn't matter. She only give the citations,
Oh.
nothing else.
Obliged.
No further argument.
Yes.
Ask someone to be here, we'll see. Yes, you want to say some citations? Two 2 GLR. Give us this.
275. 275.
What is the equivalent citation? One GLT 273. Okay.
Name? Paragraph? What's the proper?
In the state of Assam, process of determination of question of citizenship cannot be a one-way traffic, leaning only in favor of a person whose citizenship is doubted. Interest of the state is also of paramount importance in that unabated influx has the potential to affect the integrity and sovereignty of the country. Citizenship of a person, no doubt, is a very valuable right and should be zealously guarded. However, if a person does not take steps for safeguarding his interests, he does so at his own peril. Right to a fair hearing and or principles of natural justice cannot be permitted to lead to a farcical situation and to be an engine for defeating the very object of identification and deportation of foreigners. The petitioners had known about the allegations against them that they are foreigners entering India with any valid documents, at least from the time of reference, Lordship, even ignoring the earlier part under the IMDT Act from 1997. The petitioners all these years apparently did not take any step to defend their rights in the court proceedings. In the circumstances, I am not inclined to grant any further opportunity to the petitioners, as any such course of action according to the perception of the court would be self-defeating. Lordship, my second citation would be 2016 4 GLR 182. Paragraph, Lordship, name, Lordship, no, Kodvanu, Kodvanu.
Paragraph.
Paragraph 5, Lordship. And then Lordship 7 and 8. This is on the blame on the council. So Lordship will. Lordship, one more I would like to rely on is WPC 82 of 2024. 82. It was decided on 13/2/2024 by this bench only, Lordship.
WBC 822014.
2024.
Hmm.
Paragraph 12,
Decided on
13/2/2024. Just few days. Baten Paramanik. BATEN PARAMANIK. Elias Abdul Bater. Paragraph 12, Lordship. 13, 16, 18 and 19. 18 would be on the exhausting of all the remedies by the tribunal. Issue of warrant which Lordship had decided the other day. Paragraph 18, Lordship. May I read it? Now let us deal with the argument made on behalf of the petitioner by taking support of Order 4E of the Order of 1964 that a proceeding cannot be made ex parte without exhausting the aforesaid provision. The aforesaid provision reads as follows: 4 powers of Foreigners Tribunal. The Foreigners Tribunal shall have the powers of a civil court while trying a suit under the Code of Civil Procedure, and the powers of a judicial magistrate first class under the Code of Criminal Procedure in respect of the following matters, namely: E is issue a warrant of arrest against the proceedee if he or she fails to appear before it. The aforesaid provision has been inserted by notification dated 10/12/2013. The objective behind such insertion is to secure the attendance of a proceedee in case such attendance is deemed necessary by the learned tribunal, and for doing so, the learned tribunal can exercise the powers of a judicial magistrate first class under the CRPC 1973. However, the said provision cannot be interpreted to mean that even for filing a written statement for defending the case, such powers are to be exercised. In the opinion of this court, the aforesaid argument is apparently flawed, and if such interpretation is accepted, no case under the Foreigners Tribunal can proceed ex parte, which would be wholly unreasonable proposition. The aforesaid view of this court is fortified by the other provisions in the Order of 1964, which in fact contemplates ex parte proceedings. In this connection, Order 3 of the said Order of 1964 may be referred to, which lays down the procedure for setting aside ex parte order in the said provision of 3A, which was also inserted by the same notification dated 10/12/2013. And relying on this, we have and Lordship with the tertiary that that also covers in this one only. That would be paragraph 16. The last judgment 82 of 2020.
Okay.
Item number 3.
Lordship, this matter may be taken up some other day. Mr. Sharma left with the record. We couldn't find it, Lordship.
But whether he received the record or yet to be received.
He didn't, I couldn't talk to him, Lordship.
Okay. On the priority council for the parties.
Did you seek for time in the morning? No.
Time being, we had sought for time to check with the record.
Just wanted to confirm.
Actually,
Next, yes, Lordship, it would be
21st.
21st.
Maybe.
Item demand police. Item to two light, yeah. A quick spot. Reason of it, no holiday. Contested to declare today. Record. Corona case.
From reference group. Was there any specific order mark of this mark by this court on it? So, yes, the order was passed.
Yes.
What happened?
Yes, my lord. Already expiry order of 1/6/2016.
One six,
During the pending of the repetition, my lord. Already expired order 1/2016. I mean, what happened in this case, ma'am?
thereafter, a new reference was
Yes. Subsequently, a reference was made, my lord. Petitioner appear contested.
earliest reference becomes obligatory is view of the High Court order.
Yes, High Court as well as.
Given a chance thereafter in the new order, So I think you can concentrate on the new order,
Yes.
which has been, by which you have to declare against the court.
Yes, that's it. And my humble submission, my lord. My humble submission, my lord. In this case, my lord, expired order, 1/6/2016.
Subsequent is not
Contested.
expert.
And then whom subsequently contested.
Subsequently, you argue on the subsequent.
Subsequently new application. and contested matter. Declare point. I am, my lord, in the expiry order, my lord, what happened? 1/6/2016.
So, Ahmed, why are you going to expert order? That was interfered with by the High Court.
Yes.
But before that, the order was already passed.
Yes.
High Court was of the impression that your petition was yet to be considered to set aside expert.
Yes.
But in the matter of 1/6, the final order was passed.
Yes.
Thereafter, maybe technically, we are not on the technical issues, we are giving a fresh chance,
Yes.
new review.
Yes.
You had contested.
Yes.
And in this contested petition,
Declared.
you have declared the foreign. So we can make your arguments on the next case.
No, my lord, I am on the first case, my lord.
First case, I already operated.
First case, my lord, High Court order in fact as per my.
First case, we are not even taking into account in view of the High Court order of 23/6.
High Court order, my lord, subsequently passed, my lord. 23/6,
Understood.
2016, my lord.
Understood, 23/6/2016.
Yes.
You can, for the time being, forget about the first order.
My lord, last order, last paragraph case 37, my lord. Paragraph 6, my lord. Here is, if the case has not been disposed of the mean, already disposed.
Yes, saying, that don't worry about the first order.
I am worried for the first order.
You will succeed in the second order.
It is subsequent proceedings are not subsequent proceeding barred by res judicata, my lord.
There you are already held as a foreigner.
Yes.
Then you, it is satisfied.
I am on the first case, my lord, expired order. I may be allowed to contest the first case, my lord.
You have already contested the second case.
And second case, my lord, it is the no knowledge of the prisoner, my lord.
What is this?
He
Should you have said-
is a layman of
You
the
should have said
belongs to
that
a village area, my
what's
lord.
the second case. It's ultimately a question of prejudice. Have you suffered any prejudice in the second case? We will not even go into the first case security. We will say that the second case we will re-examine. First case can arbitrary because of the order of the High Court.
I put one observation, my lord.
If the
Line
first
para
order
6, my lord.
proceeding favored, then the second proceeding started, then you can bring in the concept of judicial. The first is also against you. And we are still saying that the expert order will not take into account. You have contested and interpreted proceeding. Make your argument. 359, the impugned opinion, 28/9/2021.
Yes. Here is voter list of 1966, my lord, page 64. Father's name, my lord, Pahesh Fakir.
Page
64.
Page 64.
Yes.
Yes, what is that?
And next, my lord, page 66.
64 first.
Yes,
What
64.
is there in 64?
64, serial number equals 6, my lord.
Order is out which year?
66.
66. Pahesh Fakir, father name.
Pahesh
Fakir.
Fakir. Father. Father.
Father.
Okay.
Next, my lord, page 66, the list of 1970. Serial number 754. Pahesh Fakir.
Page 60.
Bade.
70 page.
Yes, total list of 9.
Yes. What do you want to hear?
Yes. Here is my lord, 754.
754. Yes.
Next, my lord. Total list of 1985. Yes. PK. Petitioner Abdul Manan. Yes. PK. Total list of 1985.
58.
And I think he's missed out one page. There's 97 also in between.
Abdullah.
We're coming to that, okay.
58 is 85.
And page 67 is total list of 1997.
What is there?
Abdul Manan Fakir petitioner. Father name is Baher.
Ahead.
Baher. Fakir.
Thereafter,
67 my lord, total list of 1997. And next my lord, 69 total list. 69 total list. 2008.
total list of 97.
Yes. Yes, 69.
Yes. Yes. Ahead.
Here is Baher between 1988. 59 is total list of 2008.
Page
Page 69, total list 2008. Abdul Manan Fakir, Manan Fakir. Here is Baher. Next 71.
here. Thereafter,
Thereafter, total is 2008, 2011, 2015. Next, my lord, one Firas Patta, my lord, page 73. Abdul Manan, son of Baher.
73.
Of page 77, one green card issued by the Food and Civil Supply.
70.
77. 77. Green card issued by Food and Civil Supply Department. Page 77. Abdul Manan Fakir, son of Baher.
What is the date of this?
the record. Page 78, next in certificate. Bahas copy, next page 79. After all documents executed. In the next of kin, that page 59. You have two more brothers. Abdul Khalek and Dulhas Fakir. If the voters is to tell us their name. Page 68. Dulhas Fakir. Where is Abdul Khalek? His elder is Dulhas. Dulhas is younger to Abdul. And in rest, the earlier page 97 voter list. 97 voter list. There is Abdul Manan Fakir Bosira. Where are your brothers? They be separated from. Have you stated? Yes. Have you separated stated in the WS? No. After ethnic measure, they are separated. Most probably. Is there any reference in your WS? Maybe their name may appear in the voter list along with the only two persons name appear. Period number.
Yes. It's the discrepancy. Like one more question.
If in between,
Why was the second reference?
Second reference, my lord, as per inquiry report, my lord, there is a two different address. First reference, one address, second reference was in another.
Tribunal was the same.
Same people, same.
But your conduct in the first case was not good.
Yes, my lord. Yes, my lord. To my information, my lord, could not collect the documents, my lord. That's why, my
But
lord,
your
first
conduct-
engaged
your-
council
your
hand over
conduct-
the
your-
treatment.
Conduct of the petitioner in the first round of the case in this court
Yes.
was not good at all. What is your position for the court in the earlier case? That a reference case is pending since 2005-7, and you had changed your lawyer.
Yes.
And lawyer wanted some time to go by the brief. He filed a petition on 1/6/2016.
Yes.
Okay,
Yes.
and no orders was passed, the petition was returned back to the
Returned
lawyer.
back.
That was the grievance. Court on 23/6/2016.
A password.
Past order, court noted that this is a reference of 2007. You have not given the order sheet. Court is not even aware what has happened to the proceeding. The proceeding had culminated on 1/6/2016 itself. The writ petition was taken up for consideration on 23/6/2016. In fact, you filed the petition on 26/2016.
Miller,
You have not placed an order of 1/6 for the court. Is it fair?
Miller, I am not opened my mouth in this court. What happened in this case? Informed by the tribunal. Here. On the day, my lord, 1/6/2016, that tribunal did not pass any order. When the High Court order placed before the tribunal, then passed the expired order, 1/6/2016. That's my information.
Have you stated?
That's why I am not open
Have
my
you
mouth.
told, have you stated so?
No, no, my lord, no. There is no proof, my lord. That's why, my lord, I am not opening. That is the information. My lord. On the very day, my lord, earlier engaged counsel returned back. On the very day, my lord, Husni Mubarak, he has filed petition. There is also a number, my lord, but subsequently returned back, my lord.
These are very serious matters.
Yes.
We'll have to make a specific petition that to my information, till at least till the date of my filing of the writ petition, that is 26/16, no order was passed.
Yes, my lord.
Your earlier petition, you checked your file of
My lord,
26.
in my petition, my lord, page 8, my lord.
Page 8.
Yes. Page 8.
second, 18 number line. It is mentioned that earlier engaged counsel of the petitioner returned the brief to the petitioner. Accordingly, the petitioner engaged one Dimowala, advocate of the Abhay Park. The newly engaged counsel filed a letter application on 1/6/2016 along with Okalotma, which was registered as 336 dated census, but the learned tribunal returned the petition without passing any order. That is the statement.
Yes. That is the only, that is also recorded in the order of the High Court. Where it is stated that no order was actually passed or passed.
That is the information.
It should
That is the information, but there is no proof.
You have stated.
There is no proof.
What is the question of proof? That is for your information.
Yes, information.
At least make the allegation.
The information, my lord, while High Court order placing the tribunal, pass the expected order 1/6.
We go by the record. That if there is
Yes,
anything else,
that's why, my lord.
if there is anything else.
That's why I am saying, my lord, there is
No, that is, if there is anything else,
there is no
you
authentic
have to
proof.
make a specific pleading. You verify the pleading as per to your knowledge that it, the furnishing of this order, the High Court no order was actually passed. It is not left in a record.
Not mentioned.
Yeah. Mr. Green. On 17/12/2015, the OP was present. Counsel for the OP took time to file the evidence and everything. That means affidavit in chief. After various dates, accordingly, time was spent on 17/12/2015 and the matter was fixed on 28/12/2015. On 28/12/2015, the petitioner remained absent without any step. Next date was 6/16. The OP remained absent without steps. Fixed on 17/2/2016. OP remained absent. Tribunal gave last chance for filing evidence on effect. Then the matter was fixed for argument on 26th of February 2016. 26th of February 2016, OP remained without any steps.
That was fixed for argument.
Then it was fixed on 5th of April 2016. On 5th of April,
Okay, sir.
OP remained absent without steps. But the counsel for the petitioner, whom you have engaged earlier, again prayed for some time for adjournment of the case. So it was rejected and it was fixed on for necessary order on 6th of May 2000. 6th of May, again the petitioner remained absent without any step.
Admitted.
Then it was fixed on 1st of June for necessary order. And on 1st of June 2016, the order was passed. That's all. After the order of the High Court passed earlier, the tribunal again of that order of 23 or 3rd of June 2016, the tribunal said the matter was already decided on 1st of June.
ইহঁতে জমা দিয়ে না। কোনো হেৰিও নাই। Show us, where is the illegality?
In the expiry order, my lord. Only one task may be given, my lord. That is my
If
submission.
the court have already observed, right, if in the meanwhile it has not been,
My lord, that is admitted, my.
then
That is admitted. Lots of dates was given. But
And
due
they
to,
consider
due
your-
to lack of documents, my lord, could not submit the written statement as well as evidence.
in the, before we started, brother has already pointed out to you. For the timing, let us assume that ex parte order is not there. Place your second case.
In the second case, I have already deleted some documents.
Some documents will not do. Show us how you have proved.
Yes, my lord, 63 total is 70, my lord, 85, 97, 2008, 11, 2015, one green card.
Right? 66 total is name
Yes.
of one,
Pahes,
Bahid,
father,
your projected father,
Pahes Fakir,
right? Your projected father, right? Then
70 total is 63,
page 66. Bahis Fakir.
yes, Pahes. Grandfather Jahab.
The box fine. Then
And then my lord, page 67, 68, 89,
then you'll come to page 68,
87, 85.
85 totally.
85 year, what was the age in it?
No, no. 85 total is age is 30.
What happened before that? Prior to 85, you're 30 years in 85.
Here may be 2 or 3 total.
Why
Where
from
are you?
1976, from 1970, if it is 30 India 1985, then your birth year was 1955. 1955 plus 21, 1976. Right? So your name should have been there in the
There is no
77
any
election.
total in between. my lord.
Hmm?
After 72,
Hmm?
84.
Hmm.
There is not property.
Why name of your father along with you did not figure till his death?
As per written statement,
Hmm.
page 47, para C.
Hmm. Yes.
And there, unfortunately, the father of the OP had expired in the year about 1987. And sadly, his mother also got expired after 1 year of.
So 1988, 1987 and 1988. Yes. Then next line.
Next line, my lord.
Continue to read it.
By that time, the OP party had attained the age of age so as to earn for his livelihood, and he shifted to village Dalagat, which was then undivided Gwalpara, as his father had landed property in this village. The opposite party being eligible to vote, his name appeared in the voter list of 1985 as Abdul Manan Fakir, but his father name appeared only as Bahid. the Bahapati at village Talaga, shifting. In this way, his name appears subsequent to that. And re-inquiry report, my lord. In the re-inquiry report, my lord, page 31, 32, my lord. Police investigated the matter and stated that Baharuddin Bahapati re-investigate page 31. 31, 32.
Where is your land document?
Land document is page 73.
Wait, check now if you can. The translated copy.
Page of
This is the estimate.
Who is Abdul Khalik?
brother, man.
And
Dulhar. Dulhar Fakir.
Afzal Hussain. The land was allotted only in the name of Abdul Khalik, not to you and others.
There is name appeared Abdul Mannan, the son of Bahapati.
It was only allotted in the name of Abdul Khalik. 2 and 3, where from?
That part may be clarified by the revenue authority.
It is your case.
My case, I have submitted proposal to my lord.
That's enough.
So which is issued by the assistant settlement officer.
Convincing answer. Central law is there, the documents which you place for the court, it is your choice, which document you place.
This document
After
issued by
placing,
the
you cannot say that these documents are for.
Here is of Abdul Mannan, son of Bahapati. Here is Abdul Khalid,
Son of
son of
Kajimuddin.
Bahapati.
Because
No,
it's a-
Afzal. Here is the Afzal. And in the green card, my lord, father name correctly appeared. Pahes. Pahes.
So it doesn't appear a date. Which year?
That may be, my lord, the record. Reactivity of. Yeah, the senior card, maybe I have not, the green card.
itu post 71 document. Itu kena ko. Huh? 55 date of birth. ইয়াতে কিবা আছে নে দাবী গ্ৰীণ কাৰ্ডটো আমাৰ কামত নাই গ্ৰীণ কাৰ্ড ইজ নট
It is okay, it is one name, but clear. Because it is only in the name of promoted to clinical. Release it to that. So,
There is 73 is date of birth when there is one. There is 73.
Here is method.
This is the note below, but two, one for a regard. This is that
মই ওপৰত লিখা জিলা ডেপুটি কমিশনাৰে ইয়াৰ দ্বাৰাই প্ৰচাৰ কৰোঁ যে অসমৰ ভূমি আৰু ৰাজহ বিধিৰ ব্যৱস্থা আৰু সময়ে সময়ে কৰা তাৰ নিয়মৰ বশৱৰ্তী হৈ প্ৰাদেশিক গভৰ্ণমেণ্টৰ পক্ষে এই পট্টাৰ ডিপিটি তফচিলত লিখা মাটিখিনি 11 মাৰ্চ 2020 বছৰৰ কাৰণে তলত লিখা ৰাজহ আৰু স্থানীয় কৰত আপুনি আব্দুল খালেক পিতা স্বয়ংক্ৰিয় আপোনাৰ উত্তৰে দেখি
where is Abdul Khalek?
Abdul Khalek name is appeared in the Amalot page 79 next in certificate.
That is, this is Patta was created in the name of Abdul Khalek. Who else is that? Who else? Abdul Khalek Pita Bahir.
Yeah.
Next in also is one name of Abdul Khalek.
Page 70.
Mr. Amit, show us the proof that you are the son of Bahez Pokir,
Okay,
whose name figured in the village Kodamtola in the voter list of 1966 and 1970.
no one. And there is no proof. There is no proof. His name appeared in the Kodamtola. 1985 years.
That is a show that the same person, Bahez Pokir, the same person
Bahez Pokir's
that
name,
you are the son of Bahez Pokir of Dhalagasa, because there is no person in Dhalagasa by Bahez Pokir. You are claiming you are the son of Bahez Pokir
Yes.
of Dhalagasa, right?
and I also claim that the Bahez Pokir
Is your father.
and name is appearing in the voter list of 66, 70.
So kindly show
Kodamtola.
us that you are the son of Bahez Pokir of village Kodamtola.
Yes.
Show us where is it? Where from you want to establish? Which particular document? Where you have stated so
In the written statement.
in the written statement?
Yes.
Is that sufficient? Where is the shifting? How you have proved?
My lord, shifting order.
Where you
my
have
lord,
stated
pass
that
the order, my lord, shifting order.
the said Bahez Fakir had two other sons. Where you have stated so? What is the name of your grandmother?
Yeah.
You have not said because you don't know. Secondly, where in which particular paragraph you have said that these are your brothers?
Yes, my lord. The next in certificate, my lord, 48, my lord. After the opposite party born in the 1960s, about 6 years ago in the village Kodamtola, under Bagbor, yes, Bagbor, which was then the subdivision Borpata in company. His father name is Bahez Pokir, who was a bona fide citizen of India at that time, and therefore he was a regular voter in the village, and thus Bahez Pokir's name was appeared in the voter list of 19. Karachi. Karachi. Unfortunately, the father of the officer had expired in the year about 1907, and sadly his mother also got expired after one year of his father. By the time the opposite party had attained the age so as to earn for his livelihood, and he shifted to village Dalagasa, who was rather than undivided Golpar, as his father had landed property in his village Dalagasa. That's why opposite party being eligible to vote, his name appeared in the voter list of 1985 as Abdul Malik, but father name appeared only as Bahez instead of Bahez. Stated. But there is no shifting certificate. Nobody issued any shifting certificate. And my lord, regarding shifting, my lord, and regarding the name distribution in the case of Tiazul Haq, my lord.
We'll have the case laws later, please, from the materials available that you have placed before the tribunal. Show us.
All these documents annexed in the decision, my lord, which are submitted to the tribunal.
Show us where you have stated the name of your brother. How you
Brother's
have
name is,
to-
my lord, one paragraph, my lord, page 48. Para 9. Here is, my lord, about
Kindly read.
Yes. The opposite party begs to state that he got landed property at village Dalagasa, and as the Deputy Commissioner of Boyagaon has to take periodic Terasparta in his name along with their brother after due verification took effect from 31st March 2009 for a period of 20 years, wherein also his father name Bahezuddin is mentioned. Moreover, a job card by the government of Assam under the NREGA, the National Student Guarantee Employment Guarantee Act, was issued as he used to work as a labor, where also his father name late Bahez Pokir is mentioned.
You have read paragraph 9
Yes.
of your written statement.
Yes.
Come to page number 79 of your rate petition. 9.
Last.
Yes.
Who is senior?
Here is Abdul Manan Fakir Senior.
And what you have stated in para 9?
Yes. The opposite party being poor of the poorest person, the government of person, food and civil supply department has issued. He make green card with effect from.
We are not on that. Paragraph 9, whom you have mentioned as senior. Land was allotted to your senior brother.
Yes, senior brother.
And see at page 79, who is senior?
Senior. Here is
That is your written statement. Then you please come to your statement before the tribunal. Page number 57.
মোৰ জন্ম কেতিয়া হৈছিল মই নাজানো 1966 চনত দেউতাৰ নাম প্ৰথমে ভোটাৰ তালিকাত উঠিছিল উক্ত ভোটাৰ তালিকাত মোৰ খুৰাৰ নামো উল্লেখ আছে দেউতাৰ নাম প্ৰথমে কদমতলা গাঁৱত উঠিছিল 1985 চনত মোৰ নাম প্ৰথম দলাগাছা গাঁৱত ভোটাৰ তালিকাত উঠিছিল সেই সময়ত মোৰ বয়স 20 বছৰ আছিল উক্ত তালিকাত মোৰ ভাইৰ নাম উল্লেখ আছে 1986 চনত দেউতাৰ মৃত্যু হয় 1985 চনত ভোটাৰ তালিকাত উল্লেখ থকা আঠিয়া খাতুন মোৰ সেই যোৰহাটৰ
এই বছৰত
এক্সিবিট 9 হিচাপে জমা দিয়া অৰ্থাৎ উল্লেখ জমিৰ খৰিদা দলিল মই এই গোচৰত দিয়া নাই জমি কেতিয়া কিনিছিলো মনত নাই মই জমা দিয়া চাৰ্টিফিকেট সবাই কোন কৰা মই নাজানো 2 বছৰ আগতে উঠল দেউতাৰ মৃত্যু যদিও বহুদিন আগতে হৈছিল প্ৰয়োজন হোৱা নাছিল বাবে এই চাৰ্টিফিকেটখন ওলোৱা নাছিল এতিয়া এই বছৰত প্ৰয়োজন মোৰ বাবে উলিয়াইছো মোৰ ভাই জুলহাছৰ পৰিবাৰৰ নাম বাহাদুৰ দেউতাৰ মৃত্যু
দলাগাছাত হৈছে
প্ৰায় 20 বছৰ আগতে কদমতলাৰ পৰা দলাগাছালৈ আহিছে দেউতাৰ নামত কোনো ভোটাৰ তালিকা 1970 চনৰ ভিতৰত এই বছৰত জমা দিয়া নাই after 1970 no voter list is
Mayor making a statement that your father Bahazuddin has come from Kodamtola to Dhalagata will not do. You need to prove. And look at your land document. If you are saying it is your land, you do not know when you have purchased. And allotment was given to you. You are saying. Definitely it is something else. Even then we are saying.
There may be Sita copy, my lord.
We do not know.
Sita copy may be called from that.
Why should you? It is your case. You have to establish. Not
of the real fact, my lord. Otherwise, my lord.
Come to page number 74.
The deputy commissioner, my lord.
Come to page number 74.
Lordship, he read out that this was a land which was given for a period of 20 years on 31st March 2009. In his WS, he has stated that. So if it is 20 years, 2029, I think it would be over. Yes, Lordship. And the dates are not mentioned in the translated copy, making it difficult for us, Lordship.
Here is also in Assamese there.
Page 74.
Actually, we want to look at the original.
Original
serial number starts from two. I don't
Yes,
know
yes.
why
That original part maybe in the record.
you have copied with my original. You have copied with the original.
Now you have,
Translation is not mistaken.
Yes.
Translation is proper because even in the vernacular it starts from two
You-
and three.
you have homestead land of 1 kotha 19 lessers in Dag number 149. And 2 bighas homestead land, Pari, right? In 150. So altogether, how much? 2 bighas, 1 kotha, 19 lessers. Still you are a BPL holder, belongs to BPL. Surprising. In my village, whoever it is having any such land, even doesn't have the ration card. That's what we have seen. You have a landed property, you are having a ration
Only
card.
2 bighas of land.
What? Find
Only
out.
2 bighas of land, Telukopar alignment. There is so many rich persons got a ration card. My lord.
That's the reason I ask you.
Ration card, there is no bar, my lord.
Hmm.
I have also ration card in my, along with my elder.
So anything else?
No, my lord.
Yes,
My lord, regarding the name discrepancy and shifting, my lord, I am relying my lord judgment of Sirazul Hoffman. There is still, my lord, mere shifting, my lord, cannot be taken away as citizenship, my lord.
read that judgment very properly. In the morning also we have discussed the para
Sirazul
3.
Hoffman. About
judgment.
Sirazul Hoffman. Yes, I'm.
Two and three. Reported in
Regarding name discrepancy and my lord, shifting, my lord.
Volume 8, volume 3. One. Very good.
Yes,
1073 of
anything you like to place?
Yes, Lordship.
Hmm.
Lordship, I would like to start from first the written statement, Lordship.
Hmm.
Written statement is vague, not complete with details, and Lordship will give me just a moment. First, Lordship is the written statement. I'll give that citation for that. Then shifting has not been explained after 66 and 70. The village has changed and 97, 85, 2008, 11 and 15. The petitioner's father expired sometime in 1987. So there ought to have been a voters list between 1970 to 85 of his parents.
After 70,
70
after
to-
1970.
Yes, Lordship.
Up to 1986.
85
or
because he
87.
passed in 87. So there is no voters list in between of the parents which have been exhibited before this court lordship. And in the voters list has not been proved as his father has three different names. Somewhere it is Bahej, somewhere it's Bahejuddin, and
No, not on that. See, the proceeding before the tribunal
yes, lordship.
in while being inquired by the tribunal clearly stated that দেউতাৰ নামৰ কোনো ভোটাৰ তালিকা 1970 চনৰ পিছত এই গোচৰত মই জমা দিয়া নাই. Very clear. Admitted the fact that I have not submitted any voter list
After 70.
in his
But
father's
then
name
again,
after 1970.
yes, from 97 again the voters list comes, but the name is different, lordship. 1997, yes, lordship. I will take lordship to the voters list, 967. Yeah, page 67. Yes. Abdul Mannan Fakir, the father's name is Bahej in 85, but in 97, if lordship sees the first document on page 67, it is late Bahejuddin. Then after page 67, 68 is the 85 voters list where it is Bahej.
Then again Bahejuddin.
Again Bahejuddin.
It continued Bahejuddin.
Yes, it continued, but there is no explanation to the missing book, though he has admitted that he has not given it before the tribunal, lordship. And the documents which my friend has submitted in this petition, lordship, for that I would like to rely on Basiron Nessa, lordship. WPC 5493 of 2017.
4593.
Yes, lordship. No, on lordship, I'll rely on the other one. 6283 of 2016. Sajida Khatun.
2016.
Yes, lordship. It was decided on 22/5/2018. Paragraph
Please repeat
16.
25. 22/5/18.
18, lordship.
Para?
Para 16, lordship will come to para 16. 8, 9.
What is the proposal?
Proposition is the contents as per section 61 of the Evidence Act, contents of the documents may be proved either by primary or secondary evidence, lordship. And para 24.2, lordship.
What context or which document context is not?
The voters list, lordship. The voters list also, they're not certified copies, lordship.
The certified copy.
They're electronic printouts.
Electronic printer
May not be.
known.
No, lordship, I think I've made a mistake.
1966 and 70, yes. Oh,
70.
this is not for as per the provision of 76. This is not as per the provision of section 76 of the Act. Section 76 is putting up non-executive level of Ratipur case কেটে গুছি গেছে Ratipur 1 নম্বর আর একটা হচ্ছে নম্বর পর 1 নম্বর তো আরোটা no Somebody
Yeah.
Certified copy at the chief executive. लिखिए ना सेक्शन 76 कहते हैं सेक्शन बोल रहे थे ठीक लगे
May I read Lordship, one of the paragraphs, Lordship? This is from Borhan Ali, 7669 of 2016. Paragraph 21.8, Lordship.
पहला
21.7.
बुरहान अली WBC
7669 of 2016, Lordship.
2016
Yes, Lordship. (21.8). There is one more aspect though under section 79 of the Evidence Act, Lordship.
itu নহয় পড়ুয়া শুনো একটু মিল itu কি নেব
This is on the genuineness of the voters list, Lordship. And then 27.1, extending this principle, if a proceedee relies on a voters list, he has to rely on the same in its entirety and not in part. He cannot say that he will rely upon that part of the voters list which is favorable to the proceedee, but would not rely upon that part of the voters list which goes against him. For example, vital discrepancies in name, residence, and age. A document has to be appreciated as a whole, not in bits and pieces. I'm relying on this paragraph 27.1.
আর এটা there are certain other judgments of section 73
Lordship, I'll give it later.
No, we have in between, there are certain voter lists.
Yes, Lordship.
Today morning, we had another matter, it was clearly mentioned, that's what have been pointed out to district by brother. Item number 15,
15.
if you have the writ petition with you,
Yes, yes, Lordship.
you have it now?
Lordship, for the written statement one, I found the judgment. Lordship can take it down.
Look at it, page 23 of that item number 15.
Yes, page 20.
Page 23.
Item 15, Lordship.
Yes.
Which one am I-
Aziran Nessa,
Yes, Lordship, page 23 is a,
in particular,
yes,
down below you see. Your colleague might help you.
yes, Lordship.
She can help
That
you.
is missing in this one. That is why I refer to this judgment.
what-
Lordship.
That's in written Hoityo Pramanito Nokol.
Hmm.
The person concerned whose issue, his full name,
Name,
then
signature,
his
seal.
designation with date, signature.
This
That is
was,
what section 76 is. Just to point out.
yes. And this is missing in 66 and 70 voters list, Lordship. Lordship, for written statement, I would like to rely on
Hmm.
2017 4 GLR 282.
2000,
17 4 GLR 282. It's even in GLT, that is 2017 4 GLT 346.
I have to keep
346.
Yes, Lordship.
What's the chair?
Proposition is that the
What is the chair?
GLT
2017
is
4 GL.
346.
About the written statement.
Yes, Lordship. It is, this court has held that written statement Rashmi Nara Begum versus Union of India.
Prior to that, there is another case. Because in Rasmi Nara Begum, it was decided.
Material facts relevant for establishing citizenship have to be pleaded in the written statement, which are thereafter required to be proved by using cogent and reliable evidence, Lordship.
Okay.
In another judgment, Lordship, Ayesha Khatun versus Union of India report.
On what?
It has failure to disclose material facts in the written statement by itself will raise a serious question mark on the citizenship status of the proceeding.
Case number Ayesha Khatun.
2017 3 GLR 820.
Mr. Sikdar, we'll take up your case on Saturday.
No, my lord, I have, I, I have to go to Agartala on 17th. Any other day?
After 24th, Lordship.
Twenty-seventh.
My lord.
Anything else?
Yes, Lordship. Lordship, then I would like to place reliance on paragraph 30 of the citation which I've given, Lordship. What? All correctly said.
Which case?
That was Basiron Bibi, Basiron. Basiron Bibi.
Hmm.
This is on the clarification of Abdul. Citation is, it is in Basirun Bibi, paragraph 30, Lordship.
WBC number
WPC number is 1002 of 2016. तो मतलब GLB तो लिखी चलो ना. Decided on Lordship it's in GLT also, 2013 1 GLT 941.
2013.
13 1 GLT
Justice
941.
P.K. Sharma's judgment.
No, Lordship, this is Justice Bhuiya's judgment.
13-1 GLT.
One. Actually, it's not here who it's here, Lordship. 2013 1 GLT 941. No, this is Basiran.
Okay.
Paragraph 30.
No, if it is a case of 2016, how can it be reported in 2013?
Lordship, this is maybe that citation. We have written it like this as case of 16. Lordship will take the WPC number. There's some confusion, Lordship.
It may be 2018.
It's written.
Decided when?
Yes, it is 2018 1 GLT 372, paragraph
That's right.
30, Lordship.
372.
372.
Not 941.
Paragraph 30, Lordship.
Hmm.
Reliance placed in the case of Abdul Matali, alias Matleb Mohammed Supra, can be of no assistance to the petitioner in as much as it has already been clarified by this court in previous decisions that the said decision did not lay down any law and was a decision confined to the facts and circumstances of that case.
Abdul Matali by
The
Justice
first one.
Kotoki and Justice Swami, or
This is Supra here. I did not find that one. I'm reading it out from Basirun Bibi. Regarding discrepancies in the voters list, which the petitioner contended were not her creation being entered into by officials of Election Commission and therefore should not be used adversely against the petitioner, such contention is without any substance. The voters list were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portion of the voters list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has
okay,
to
we'll
be
look into it.
Yes,
Any
Lord.
other?
And the certiorari will come, list of certiorari will come. And the Kuraj Patta Lordship is a document which was issued only in the year 31/3/2009. Since it's a post 1971 document that cannot be relied upon.
Yes. Okay. Heard Mr. Abdul Matuk, counsel for the petitioner, and MS Devarma, any counsel from the petitioner, writing of H. Kuli, for AIL, and Mr. R. Talukar, government. Where is the records? Order reserve. Borua. Order. Go ahead. Okay. Itu file order ko. The file. Itu file order. No, no problem. I to take it. Sure.
Take your time. 27.
You talk.
27.
Lordship.
What?
Mention item
Talk.